Good afternoon, and welcome to the final and championship round of the Fall 2026 Durham, Pittard, and Spalding Moot Court Competition. Thank you all for coming and being here today. This is the culmination of 2 weeks of intense competition, right? Classmates against classmates, roommates against roommates competing to make it here to the final round. Our two teams are to be congratulated today. Representing the Petitioner, we have Team 16, Katie Stepek and Savannah Walker. Representing the Respondent, we have Team 15, Jake Hatcher and Sam Hagan. Let's congratulate our two final round teams. All right, so before we can get into the competition, I do have some thank yous that I need to go through to make sure we highlight everyone who pitches in to make this competition a success. First of all, I want to thank the sponsor firm of Durham, Pittard, and Spalding. They are the new sponsor for the fall competition. We're excited for this new partnership. They provide financial support as well as judging support. We have here today Chief Justice Shelby White from the firm, who is also a Baylor lawyer. We're very excited to have her back, and we want to thank the firm for their support. So let's thank the firm as well. Trying to keep this brief, so I also want to thank the Baylor Law faculty and staff. I'm not going to go through everybody's names because pretty much it's everybody at the law school helps out with this, right? From making sure you have rooms, to judges, to podiums in your rooms, to refreshments outside, making sure the PC folks don't eat those refreshments. It's all the faculty and staff, so I really appreciate that. Also, this is a student competition, right? We've got student competitors, student judges, we have students running the competition. So I do want to go through and thank the Moot Court Board for all of their hard work. So we first have the barrister officers. They took on the tremendous task of wrangling over 150 barristers. You all will know the exact number. But I want to thank Marianne Heffley and Morgan Dawson, our barrister officers. And then we've got our vice presidents who do a little bit of everything. We've got Lily Wilson and Shelby Trudeau. They will be back in the spring as well as presidents. So let's thank them for taking this on. And then we've got our presidents, Noah Sullivan and Evan Goodman. This is their second time around. They really put in the hard work to run this competition, and we want to thank them as well. All right, a few more thank yous. I want to say, too, for barristers, thank you all for judging. We couldn't do it without you. Thank you to all of you who competed as well. I want to go through quickly our judging panel. We have on the judging panel, we've got the winners of the spring competition. So we've got Caitlin Stevens and Kelsey Crow. We have professors. We have Professor Berry. We have Dean Esprit. We have Professor White, and then we have Professor Underwood as well, and then finally our Chief Justice. So thank you all for judging. I want to highlight, too, I know I thanked Professor Berry for being a judge, but we also need to thank Professor Berry, right, for being an important part of this competition, helping sure it made sure it ran smoothly, and teaching LARC 3. So thank you to Professor Berry as well. Just after this is over, right, the judges will retire to deliberate. That should take about 15 to 20 minutes. We've got refreshments out in the hall that we can enjoy during that. I think that's everything I have. Did I forget anything? All right, so that's it for me. We'll let the Chief Judge call the case.
So in the Supreme Court of Texas, docket number 22 BLS 015, Laura Feathermill versus Jeremy Fusamir. Petitioner, if you're ready, go ahead and get started.
Chief Justice, Your Honors, good afternoon, and may it please the court. My name is Catherine Stepik, and along with my co-counsel, Savannah Walker, we will be representing petitioner Laura Feathermill. There are two issues presented in today's appeal. I will be addressing the first issue, why this court should abolish the common law invitee licensee distinction for premises defect claims. And my co-counsel will be addressing the second issue in the alternative, why this court should recognize petitioner Feathermill as a public invitee when she was injured by a dangerous condition on the respondent's property. With the court's permission, we'd like to reserve 2 minutes for rebuttal.
Granted.
Your Honors, this case is about whether Texans should be denied recovery based on an arbitrary system of labels. The invitee licensee distinction is outdated, unfair, and unworkable. Because of this, we ask this court today to reverse summary judgment in favor of the respondent for 3 main reasons. First, the distinction promotes unfairness within the law by imposing duty arbitrarily. Second, it perpetuates outdated property concepts that no longer reflect modern expectations of safety. And third, it overcomplicates the law, leading courts to manipulate it to produce desired results. To my first point, the invitee licensee distinction produces fundamentally unfair results for Texans. Rather than focusing on the defendant landowner's conduct, liability hinges on the visitor's purpose for being on the land. This is out of alignment with the rest of negligence law, and its results are counterintuitive. For example, in Catholic Diocese of El Paso v. Porter, teenagers suffered severe burns when they were injured due to a fire that broke out while they were volunteering at their church festival. The court labeled them as mere licensees, and so the church owed them a lower duty of care than they did to every other person who was attending the festival that day. This demonstrates unfairness of the application of this distinction. Because the teenagers were mere volunteers and so did not provide the church with any economic benefit, they were not even allowed to have their case heard on the merits. And similarly, in Mayer v. Willowbrook Plaza, employees parked their vehicles at a shopping center that they worked at, but left and then returned later. Although unknown to them, during that time, they had transformed from invitees to licensees, and so were owed a lower duty than they would have been just a few hours earlier.
Are you advocating for one single negligence standard, or are you leaving trespassers with their own standard?
Your Honor, we're advocating for a single duty of reasonable care for invitees and licensees, but trespassers we would leave alone.
Okay, so I have a question based on, if we're leaving trespassers kind of in their own category, what some of these courts have talked about is trespassers you still run into the same problem. If you're taking trespassers out and they have their own separate way that they're treated, you still run into a problem where, for example, in the case where the woman came back to the parking garage, or was lured back to the parking garage and ended up being sexually assaulted there, she was, I mean, for all intents and purposes, she's a trespasser. She was not there in that parking garage for business. So how are you solving for this issue of, we're still trying to draw lines between different people for different purposes? How does the general negligence standard solve that, or does it solve it?
Your Honor, with the case you're referring to, Mellon Mortgage Company, the reading on that case is that the strictness of the invitee licensee trespasser distinction as it stands right now made it so that the court really had to twist the doctrine a bit in order to fit Holder into one of those categories. Although they avoided applying it in that situation, the rigidity of the doctrine made it so that there really wasn't another option for Holder to be considered within the duty element. However, if we were to get rid of that distinction, Holder does not need to be forced into some predetermined duty category, but rather we can examine the case based on reasonable expectations.
Okay, but if you're leaving your trespassers in their own category, do you not still run into this sort of bleeding over issue between trespassers and what are now your kind of general anyone else who's on the premises?
Your Honor, there's always going to be some line drawing issues. However, we also need to be aware of the Texas legislation in Section 75 of the Texas Civil Practice and Remedies Code that states that landowners that preserves the common law duty, the common law limited duty owed to trespassers. And so,
Well, counsel, if
although-
we're going to continue to engage in line drawing, where can the landowner see their liability? Because right now you can see, I don't owe any responsibility basically to trespassers. I need to be careful with licensees, and I owe a reasonable duty to invitees. So they know what they're supposed to do. If it's just pure negligence, how would a landowner know what they were supposed to do?
Your Honor, we propose that the landowner would know what they were supposed to do just as they would in any other type of negligence case. The reasonable care standard is applied broadly across the board in other areas of negligence law. And while it may seem that getting rid of that standard would promote unpredictability and instability within the law, it actually is the case that in practice, the distinction overcomplicates the law. And we can see this in cases like
It would seem like
Mellenborg.
to me that everyone would build more fences. Nobody on my land, because I don't want to take the chance that you might get hurt here and some jury might hold me responsible. So my belief is more fences is what happens if we agree with you.
Your Honor, Texans can always make that decision to put up a fence. However, it is the case that most landowners and entrants alike are not aware that these status labels even exist. And so for that reason, their behavior is not likely to change, particularly with regard to entrants. And then your everyday Texas landowner is not going to necessarily, their expectation is that they're held to an ordinary standard of care.
Why do you say that? I mean, is there something you feel, or is there some data somewhere that says that people don't know what their responsibilities are on their own land?
Your Honor, when it comes to an everyday Texan, they aren't aware of Texas tort classifications.
See, I kind of disagree, and I won't ask you
Okay.
anymore, but I kind of disagree. I think that if I own land, I know that if somebody trespasses on it, it's too bad for them. I also know that if I let somebody on there to hunt or fish, I don't have to follow them around and make sure they don't get hurt. And if I invite you on there as my guest and I'm getting a benefit from that, I need to take care of you. So I may not be able to enunciate legal standards, but I know that all those people are treated differently. I think I'm a normal Texan.
Exactly,
Debatable.
Your Honor. Exactly, Your Honor. And it's important to clarify that what we're advocating here is not strict liability, but rather a reasonable care standard that flexes to the circumstances. And
Can you talk a little bit, so if we run through the hypothetical of, I've got someone who comes on my land to fish or hunt and I allow them to come on versus I am running a business on my land and I'm inviting people on. If we're under the general negligence standard, how is everyone gonna be treated?
Yes, Your Honor. So it would be by this reasonable standard of care. And so, for example, when we're talking about your average property owner who invites maybe a few guests over in their small property, that reasonable care will look different for them than, say, Walmart, which hosts hundreds of people on their premises every day. And so the strength of this standard is that it does allow to flex with the circumstances.
Let me ask a question. How does that work with the jury? Is the jury instructed that in this case reasonable care means one thing, in another case it means something else? Or is it just thrown wide open to the jury? What is the jury asked to decide, and how are they instructed on it?
Your Honor, the jury would be asked to decide, as I have said, what reasonable care means in these circumstances. And so in terms of the exact wording of what the instructions would be, this could flex, and the terminology itself may be used in some cases if it's helpful. However, we're not proposing abolishing the wording altogether.
How does that distinction of what if we have to decide how to instruct the jury and there's a bunch of arguments about that, how does that make things more efficient? I mean, you're arguing for administrative efficiency, and I don't understand how, if we don't know what we're going to tell the jury, we're going to tell them one thing on this issue and one thing on this, how that doesn't counteract the solution that you're here arguing for.
No, Your Honor. The jury would still be, it would be similar as it is into every other area of negligence law. which the reasonable standard of care has operated properly. And
So a landowner would owe the same standard of care to anybody that comes on the property, regardless of whether they come on by invitation or whether they come on for their own business. Are you saying that we just judge we throw it to the jury and say, was this reasonable or not? Is that the way it works? I just can't vision how this works with the jury.
Your Honor, the way it would work with the jury, to clarify, are you asking specific instructions or?
Yeah, it
Okay.
could be that. I just, I think that we can agree that as Judge White said, he's gonna treat people who come on the property differently depending upon how they ended up there. We just pitch that to the jury and say, well, I thought that they were just on their own business, they were a visitor, and so I didn't think I needed to look out for them. And let the jury decide whether that was negligence or not. Is that the way it works?
Yes, Your Honor. One thing to note is that the actual invitee licensee distinction was developed during feudal times. And so in that situation, landowners were generally part of an elite upper class.
Let me ask you another specific follow-up to that. Under the licensee standard, the property owner doesn't have a duty to inspect the land, correct? Requires actual knowledge of the dangerous condition before they have to do anything, correct?
Yes.
And that's what the trial court ruled in this case. If it's an invitee, they do have an obligation to inspect, right?
Yes,
Now,
Your
if we
Honor.
throw out those distinctions and throw out what you call hundreds of years of arbitrariness, and we just roll it out to the jury, if I'm a property owner, do I have to inspect before somebody comes on my land or not? What's the answer? The answer is we don't know until the jury renders a verdict in a case, do we? And that answer may be different from case to case. Isn't that arbitrariness?
No, Your Honor. It allows us to have the jury make that decision by applying modern expectations of safety. And
But if I'm a homeowner and I'm thinking about inviting people to take bluebonnet pictures on my property, under current law, I have a pretty good idea if I have to inspect. But under your system, I won't know until I get sued and the case goes to trial what my obligation was.
Your Honor, our proposal would incentivize landowners to act with increased safety if they were having people onto their land.
So you want to increase the burdens on the landowners?
Your Honor, we want to balance the burdens across both plaintiffs and defendants. And so what this means is that rather than a plaintiff having their case dismissed out of the gate on summary judgment, they are allowed to have the merits of their case heard. And the issue with precluding jury application is that it often means that what really should be a breach question, the meaning of reasonable care in a given circumstance, is dressed up by judges as a duty question, and thereby allows judges to perform a role that should be left to the jury.
If something is arbitrary, though, you talked about incentivizing the landowners. I mean, if I'm a landowner, I would be incentivized by knowing under which duty I have depending on the status of the people that are on my property. But now if that's gone away, if we remove the distinctions, what's the incentive for me there, as you alluded to?
To clarify, the incentive to allow people onto their land?
Well, you were saying that the landowners will be incentivized if the classifications go away. And so if it's arbitrary and they don't know where the standard is, what's the incentive there? Why would that be more advantageous for landowners than it is just by knowing the set standards and duties that are expected of them?
May I briefly answer and briefly conclude?
Yes, absolutely.
Your Honor, the landowners would, as I said before, the landowners are generally not pouring through tort textbooks to discover which status and which duty they're going to owe each person who's onto their property. Texas law values safety, and we want to encourage landowners who are allowing people onto their property to act with responsibility. And for these reasons, we respectfully ask the court to reverse summary judgment and allow Ms. Feathermill's case to be decided on the merits. Thank you.
Chief Justice, Your Honors, good afternoon. May it please the court. As my co-counsel stated, my name is Savannah Walker, and together we represent Petitioner Laura Feathermill on appeal. Today I'll be arguing in the alternative of my partner and why justice for Ms. Feathermill and plaintiffs alike demand the recognition of Section 332 of the restatement, otherwise known as the public invitee doctrine. Texas premises liability was originally designed to operate like the scales of justice, balancing both visitor safety and landowner freedom. However, with the change in modern land use, the drastic growth in communication platforms and social media, and a shift in societal expectations that value transparency, accountability, and community safety, the scales have tipped too far in favor of landowner defendants who use premises liability law to disclaim responsibility for easily discoverable conditions on their land. Today is an opportunity for the court to address the unfairness perpetuated by the current common law. In restoring balance to the scales and to restore the original goals of Texas premises liability, the petitioner asked the court to adopt Section 332 of the restatement and recognizing public invitee doctrine and thereby reversing summary judgment in favor of the petitioner for 3 key reasons. First, a public-facing invitation test is more equipped for modern society. Second, because a public-facing invitation test is more fair than the current mutual benefit test. And third, because the test applies to Ms. Feathermill's case, and therefore the respondent has an applicable duty of care. I'd like to begin by addressing to the court and clarifying what the petitioner asked of the court today. The current test to distinguish between licensees and invitees is the mutual benefit test. Essentially, it tests whether the visitor and the landowner exchanged mutual economic benefit in order to create a higher duty of care, invitee status. However, the petitioner stands before the court today to ask them to adopt a public-facing invitation test, which instead involves a more clear and objective trigger of invitee duties, a public-facing invitation from the landowner to the public to create the status. By adopting such a test, the court would be adopting Section 332 of the restatement and the public invitee doctrine altogether. I'd like to begin by addressing why the public-facing invitation test
As you do that, would you tell us what our responsibility is to trick-or-treaters?
Your Honor, are you asking for people who...
Yeah, like they seem like they're public invitees, and so now I have a responsibility to protect them. And that's not what I think I have today.
Yes, Your Honor. So in the case of trick-or-treaters, there likely isn't an invitee status. However, it would, of course, depend on the facts of the case. Because
Well, I mean, the standard one is, my house is decorated, the lights are on, you come up here and you get a candy bar. So is that make those people public invitees to whom I owe a duty to protect?
The answer to that is that it depends, unfortunately. If there's signs that say, if there's signs or inviting,
Counsel, sorry. I mean, I would say 75% of people in my neighborhood have a welcome mat in front of their house. If they have a welcome mat, for example, and we've got decorations, come for a candy bar, would that mean that in that hypothetical, they would have a duty of care? Is that an example of something you would apply that to?
No, Your Honor. A welcome mat is drastically different in context than a pictures welcome sign on a field of bluebonnets that is locally notorious and famous for families going to take pictures. Additionally, to answer the trick-or-treater question, it is contextual because it depends on the way that the landowner treats it. If there's a haunted house...
You just got up here and told us that it was going to be a more clear trigger than our current system. And your co-counsel was talking about how this would, less arbitrary. You're saying it's going to be more clear. And the first answer right out of the gate is it depends. So if it just really depends, why should we change our system at all if it currently just depends? Like, what's the benefit here? It sounds like it's just as arbitrary.
Your Honor, because a public-facing invitation test not only provides a more clear rule, it also eliminates the arbitrary outcomes and unfair results of the current test. For example, in many cases, as my co-counsel mentioned, in many cases, the courts specifically stretch, work around, or completely avoid altogether using the test because it's too harsh or strict an outcome. In Carlisle, for example, a case by this very court, the court skirted around the mutual benefit test because it felt it was too harsh a construction to hold that a child plaintiff's presence on the store owner's land would be create licensee status because the child didn't provide the store any economic benefit. So the petitioner asserts today that if the court must continually stretch and work around the rule, then the rule is broken. And when the rule produces unfair outcomes like that of Ms. Feathermill's case and all the other injured plaintiffs who get their case dismissed at the outset, then the court should and must consider changing the test in order to provide justice.
So are you assuming that you would be considered in a public invitee under the scenario, and why? Because it seems like we just have a sign that says welcome, which I think you've already spoken about. That's not necessarily an invitation. So
Yes, Your Honor.
What's different about this?
Yes, Your Honor. In Carlisle, this very court quoted that a mere passive acquiescence involves no liability, but if a landowner directly or by invitation induces the persons to enter on the land, he thereby assumes an obligation. See, Miss Plaintiffs...
Trick-or-treaters. Induce them to come onto your property. So trick-or-treaters, you gotta protect them.
No, Your Honor. Respectfully, I have to disagree with you. In the case of Ms. Feathermill and the respondent, the affirmative conduct to put up a pictures welcome sign is vastly different than perhaps leaving a bowl of candy out in your front yard. And to that point, that's why I said it will depend. It will depend on the conduct of the landowner, and that is the beauty of the public-facing invitation test.
The reason I'm fussing about this is because not many of us have a field of bluebonnets that people want to visit, or a garden, or anything else that the public wants to come see. It's our backyard. All of us, okay, so a bunch of us offer candy to kids every year. So we are likely to be more impacted by this ruling on Halloween than we are during bluebonnet season. So I feel like there needs to be something that says, oh, well, if you do this at Halloween, you have to protect them. If you do this, you don't have to protect them.
Your Honor, during Halloween season, if you put a sign up that all are welcome to come into your haunted house and a child wanders in and breaks its leg, the child was likely a public invitee and thereby injured by a dangerous condition on your land. And I would assert that you are, or whoever is the landowner, is liable for that injury. And that claim should be weighed by a jury and not dismissed at the outset of the case. And the very beauty of
if I have the usual Halloween circumstances where you come up to my porch and you ring the bell, you yell trick or treat, and I give you a candy bar, and you fall off my steps, and I could have put a handrail up there and you wouldn't have fallen, is that me, or is that you for falling?
Your Honor, that's unfortunately on the child for falling, but it all goes back to the Carlisle quote. A mere passive acquiescence, passive conduct, passive permission onto the land, it's very different from invitation and inducement. In Ms. Feathermill's case with Mr.
But we induced
Fusemeyer...
them with the candy, and we knew they were coming, and we decorated our house, and we left the porch light on. I mean, that's an invitation. And so we have a duty to protect them, and we should anticipate reasonably that if we don't have handrails on our steps, people will fall. So now I'm paying for the fall, right?
No, Your Honor, respectfully, it's still going to depend on the context. It depends if you put up a sign. It depends on if there is an invitation by the law. In Ms. Feathermill's case, the sign clearly said pictures welcome, which directly aligns with what this court said in Carlisle. When a person induces somebody to enter the public land for the purposes of which the land is held open. The land was obviously being held open for people to enjoy the native bluebonnets, and the pictures welcome sign induced those to enter and take pictures with the bluebonnets. That's very different from a child passively coming up to your porch and grabbing candy out of a jack-o'-lantern bucket or ringing your doorbell also.
Counsel, of the states that still apply the trichotomy, how many of them fail to recognize public invitees? I would assume that's a minority position, isn't it?
Your Honor, it's a minority but a growing position. I don't have the exact statistics or data in front of me today to be able to tell you exactly how many states have adopted the public invitee doctrine, but it is a moving doctrine across the United States because it recognizes the realities of modern life, and it goes away with the unfair and arbitrary outcomes that produce a host of litigation and lengthy litigation like the one that we're in currently.
And there's already Texas Court of Appeals that have applied the public invitee doctrine, correct?
Yes, Your Honor, and the split and the fracture in the lower courts only underscores the need for the court to speak decisively today and to give the guidance on the situation. The Porter Court in 2021 specifically did not address the public invitee issue because neither parties had argued nor briefed it to the court. So today is the court's opportunity to hear the argument and to decide that Texans deserve public invitee protection.
Are there any Texas cases that have classified church attenders into one category or another?
Your Honor, not that I know of in front of me today.
Do you think the typical person attending a church would be a public invitee?
Yes, Your Honor, I believe so.
Is that good?
I believe so. And with the church example, what the petitioner is really asking the court today is to realize that when people go onto land that is held open to the public and they're invited on the land, they are thus foreseeable visitors on the land, and the landowner should operate in a condition in foreseeing those visitors to make it reasonably safe for them to enter and to not be injured from dangerous conditions on the property. As my co-counsel stated, the petitioner is not asking for perfection or for strict liability, but merely reasonable care under the circumstances of the landowner and the visitor, both.
It seems like a lot of this is going to boil down to what is an invitation, what constitutes an invitation. And I know, I guess there's some dispute. That learned Justice Counselor in the opinion below argued that the undisputed facts in this case establish as a matter of law that there was an invitation, that your client was a public invitee. Are you asserting that before this court? And help me on the invitation. What is an invitation? We have porch lights on with candy. Is that an invitation? Do we have a welcome sign that says photos welcome? Is that an invitation? How do we decide that?
Your Honor, the restatement, the second restatement, specifically the comments of Section 332, do give guidance on what constitutes an invitation under the law. I don't have the restatement in front of me today, but it does mention affirmative conduct to induce or impliedly induce entry onto one's premises, and I think that matches perfectly with Mr. Fusemeyer's case here. Another reason why adopting the public-facing invitation test makes sense, not only for this case, but for Texans all across, is because it recognizes the fact that plaintiffs or visitor presence on the land is not confined to merely monetary exchange and the benefit exchange, but that the presence can actually bring a host of intangible and unmeasurable benefits. I'd like the court specifically to look at the record on page 3 that Mr. Fusemeyer was planning to sell this property eventually. So he is not only gaining reputational benefits, but also gaining an increase in land value that he's going and planning to cash in on one day. And may I briefly conclude? And in the face of the injustice faced by Ms. Feathermill and plaintiffs alike, we ask the court today to balance those uneven scales that unreasonably favor landowner defendants and no longer give them an escape hatch from liability. We ask that the court adopt Section 332 of the restatement, reverse summary judgment granted to the respondent, and remand the case to the trial court to have Ms. Feathermill's claims on the merits. Thank you.
Thank you, petitioners. Respondents, go ahead.
Chief Judge, Your Honors, and may it please the court. My name is Jake Hatcher, and I, along with my co-counsel, Sam Hagan, represent the respondent in this case, Mr. Jeremy Fusemeyer, in asking the Texas Supreme Court to uphold the decision of the District Court and the 16th Court of Appeals. As you have previously heard, there are 2 issues on appeal today. I will be addressing the first issue, whether Texas should uphold the common law tripartite classification system for premises liability cases. My co-counsel will then address the second issue, showing how the district court correctly determines that Petitioner Feathermill was a licensee when she was on Respondent Fusemeyer's property. Your Honors, for over 120 years, Texas has reaffirmed, upheld, and protected the trichotomy classification system because it provides stability, predictability, and fairness. Fairness means striking a balance for the interests of each party in the dispute, not favoritism that puts burdens on landowners at the benefit of expansive negligence litigation.
Well, when you talk about predictability, counsel, we have a lot of times, admittedly, convoluted our definitions of what a licensee or an invitee is or a trespasser is in order to make it fit what we feel is the appropriate resolution for that particular case. Wouldn't the position that the petitioners are advocating for, wouldn't that be a better method of allowing this sort of uniformity of kind of decision making? Because now the question of duty is not in the court's hand anymore, it is a breach question for the jury.
Yes, Your Honor. I would respectfully disagree and state that because we can actually flex these categories to the facts of our case, it goes to show that the trichotomy is not as rigid as the petitioner would like us to believe. And when
if we're looking at the flexibility, doesn't that sort of eliminate the benefit that you're talking about, which is that the law is so clear, we already know, landowners know what categories these people fall into, but if we flex these categories, don't you lose any of that benefit anyways?
No, Your Honor, I don't believe that we lose that benefit. And I think that this distinction is clear for landowners that know of the responsibilities that they owe. The question for the jury is breach, and whether or not the landowner breached the duty of care that they owed. What the trichotomy asks is, what was that duty that was owed? And that's why it's a question for the judge to answer and a judge to set at the outset of litigation. That's why it's important. And also going to your hypothetical, it is okay that the courts can say, in this particular case, you're a licensee or you're an invitee. And that's good for the landowner and it's good for the petitioner as well, as I'll talk about later in my speech on the balancing act that the trichotomy allows for litigants. In support
like
of that.
100 years ago, Texas land was bigger. If you owned a house or a plot of land somewhere, it wasn't that you were wall to wall with your neighbor. And now it is. Our big cities and our well-developed areas, they don't have broad expanses of property with them. And I say that to ask this: hasn't our perception of what we owe to our neighbors changed in 100 years in terms of keeping them safe?
Yes, Your Honor. For the most part, I would agree with that your perception changes, and that really depends on the land that you owe. If I'm a renter in an apartment, I'm not really concerned of what I owe to my neighbors as long as I'm not knocking down their wall.
Yeah, but I mean, houses are still like crammed together now.
Yes, Your Honor.
And
My
they
house.
don't have these big, broad expanses where you can kind of tell, hey, what's that guy doing on my land?
Yes, Your Honor.
I'm worried about that, or I need to go look at my land. You have a postage stamp of grass out there. And the point is, I mean, don't I have the ability to and the obligation to socially, in a social system, to make sure people don't get hurt?
Your Honor, that depends on the context of why that they are on your land in the first place. If you have a trespasser on your land, no, you don't have that duty to them. But if I'm inviting somebody over for dinner, I have a duty to warn them of things that I know is a problem with my property. And I think that's completely fair and reasonable
Well, yeah,
under
but I
our
mean,
standards.
if I live in one of those neighborhoods where the houses are close together and the yards are not very big, what I know about things is that people are going to be traipsing across my lawn all the time.
I live in
put
one
up
of
a
those
fence.
neighborhoods, not typically, Your Honor.
Sorry?
I live in one of those neighborhoods, and that's not typically the case, Your Honor, at least not on my yard.
Okay, but you would concede that there is no barrier that exists to keep people from coming onto your yard.
There is
in the smaller, and where the houses are, very close together, there just aren't barriers. There's no barbed wire. There's no wooden fences in the front. I mean, none of that really is keeping people. And so, if we look around society today, we see that people walk across people's property all the time.
Yes,
Now, don't I have an obligation to make sure those people don't get hurt?
No, Your Honor. And I will agree with the first part of your question that you say, that yes, we typically don't have barbed wire going across people's lands or high fences, especially in tract home neighborhoods, which is not the case here in our fact pattern.
I understand that.
But also, I don't think that I would owe a duty to somebody who's simply walking across my yard when I have not invited them to do that in the first place, or have no expectation for them to do that at all. That's their choice to walk across my lawn, and they assume that risk.
But isn't it different now that we're talking about a postage-sized piece of yard versus a 100-acre ranch, that the duty is so small for me to look out in my front yard and go, oh yeah, there's a big hole there, maybe I should put a sign up, or maybe I should warn my neighbors that walk through here, compared to if I have a ranch that's 100 acres, like, yeah, it's a big burden to go inspect that property, and it makes more sense for a licensee or an invitee, someone I know is coming on the property, that I can forewarn them, to have that sort of distinction of duties, compared to now, like, anybody can walk across my yard, and if they trip and fall, I could go, yeah, I did know that was there, sorry about that.
Your Honor, I would contend that we do owe a duty to warn about injuries that could potentially happen on our land, which is what our client did in the case. If you actually look at this welcome sign that's been referred to numerous times in the record, he also warned about fire ants that he knew were an issue on the property. And so he was applying and acting in the duty of care that he owed to the clients under the trichotomy. And sure, land may look differently, but that's a question for the judge to ask when that question comes up in a lawsuit. And I'll further present two reasons why the trichotomy should continue to be used in today's system. First, why we should uphold the principles of stare decisis and continue using precedent that we've established for over a century. And second, why even if we wanted to address this issue, this court itself has stated it's best left to the Texas legislature. On that first issue, on why we should uphold precedent. As I previously stated, for over a century, Texas Supreme Court has defended the trichotomy. Since its initial adaptation in Galveston Oil in 1888 to the Mellon Mortgage Company case that was referenced earlier in Petitioner's speech in 1999, and even in United Scaffolding of 2017. Each of these cases represents an opportunity that this court had to abolish the trichotomy on different fact patterns, and yet still held true to its commitment to upholding it.
Let me ask you a question about that. But by my last count, a slight majority of states have now rejected your position on this, and that's certainly the trend. Why are so many states rejecting your argument, and why are they all wrong?
Your Honor, I would respectfully disagree that it would be a slight majority. Actually, only 12 states within our jurisdiction have abolished the trichotomy in favor of general negligence principles.
Well, 26 of them no longer recognize the invitee licensee distinction.
Under common law, but many of the
Right.
jurisdictions do it through their legislature, which I will actually address later on in my speech, which I can go to now. Of those 12 states that are using general negligence principles without the trichotomy classification in place, have retroactively created fallbacks and safety nets through their legislature and also through their common law courts in different scenarios.
Shouldn't we leave this for our legislature then? Why is that a question for us? Shouldn't we let the legislature handle this big of a change then, if that's what other states are doing?
Absolutely, Your Honor. That's exactly my point, that this is an issue for the legislature to have. They've already codified what duties are owed to trespassers. They've already codified duties underneath premises liability doctrine, and they have been silent on the issue of distinguishing between an invitee and a licensee for over a century, which, because this is such a fundamental policy decision with economic and social impacts, they know that the trichotomy is so interwoven with insurance markets, with commercial costs, that abolishing it would do much more damage to our system than it would do good. And it actually increase insurance costs for homeowners and landowners, which is the exact opposite of what they're trying to do in many bills that they have pending within this session now.
So, but isn't this a common law doctrine?
Yes, Your Honor, it was
So
traditionally created.
Isn't it our doctrine to modify? Like, you're saying it belongs to the legislature, but we're the ones that created it, so why are we not allowed to change it as we see fit?
Yes, Your Honor. I would not say that you're not allowed to do that. This court, of course, has the permission to do that with common law created rules. But this court itself stated in the United Scaffolding case of 2017 that this issue needs to be left to the legislature because it is so interwoven with social and economic concerns, such as commercial costs for properties, insurance markets, insurance liability for landowners, municipality liability, and public safety standards. The judiciary is not saying we don't have the jurisdiction to overrule this. They're saying this is best left for the legislature to handle. And the legislature has said this is working just fine. That's why they haven't addressed it for 120 years. But when we also look at the other jurisdictions that are using a system of general negligence, such as Colorado in 1978, where they abolished their common law distinction of a trichotomy, but then retroactively created safety nets and categories through their legislature. We can also see this with North Carolina, where they also modified their category entrants. But common law jurisdictions still use entrant categories to define duty and scope of that duty owed to the entrants on their land. So, despite what the petitioner would like us to believe, that this is a growing majority, it's simply not the case. And even in jurisdictions that have abolished the trichotomy, they are using entrant categories because they know this question of duty is meant for a judge and is important to litigation. But I also want to speak on this idea of fairness, since the petitioners want to talk about being fair to plaintiffs. We think this is a very one-sided approach, because what they are saying is it's only fair to allow a plaintiff's case to go through without looking at the duties and the costs that would go towards a landowner. Now, opposing counsel discussed fairness by saying Ms. Feathermill's case would not be able to go to its merits simply because of an outdated and ancient law label. But this is refusing to look at the fact that Petitioner Fussmeyer didn't breach any duty of care. As was noted in the record, he was acting within his reasonable expectations and was warning about the duties that he did owe. What the petitioners are asking for is not fairness under the law, it's favoritism towards plaintiffs. They're asking to allow negligence claims to go through despite status, despite precedent, and despite liability that's been in place for over a century. This is not fairness under the law that the trichotomy has for over a century developed, protected, and maintained. And this court itself has stated as such. But let's move into this second point that I have, speaking on why this is an issue that's best left to the legislature. As we've already talked about, other jurisdictions are already using their legislature to either codify rules that are owed under entrance or to simply state that these are owed altogether, that the invitee licensee distinction is important. But the Texas Supreme Court itself has stated that large-scale policy shifts in premises liability are best meant for the legislature. But why is that? Premises liability touches more than just private property rights. It also touches widespread social and economic concerns. And as we all can agree, property rights are special. They're unique. That's why every other area of negligence law does not have this as a question of law for a judge. But it is a question of law for a judge in this context. Because property is
being widespread, but I think your petitioners already said they're still leaving trespassers in their own category. So really we're looking at eliminating licensee versus invitee, which really is not that big of a distinction to begin with. So why is this going to be so widespread and so kind of affecting these kind of other property law areas like insurance and economic development and things like that? It doesn't seem like there would be that big of a difference between me inviting you onto my property, like my friends come over for dinner, versus the plumber comes to fix something on my house. Why do I owe them different duties of care?
Yes, Your Honor. The distinction is actually very critical, and the invitee category is meant to be narrow because it is the highest duty that is owed to somebody who's coming on your land. It's meant to be small. It's not meant to apply to everybody. And the reason why it is so important is because of the burden it ends up putting on the landowner, right? And we recognize that mutual economic benefit is what it classifies an entrant as an invitee, i.e. somebody shopping at Walmart. Walmart owes a higher duty of care to that entrant versus me inviting somebody over to my house for dinner. I owe them a duty to warn about the dangers that I know are prevalent on my land. That distinction is critical, and I wouldn't actually agree that it's just small, wouldn't have an impact. The impact that I'm referring to is abolishing the judicial common law trichotomy classification and the impact it will have on homeowner and landowners' insurance, and specifically also in commercial costs.
What about judicial efficiency here? Wouldn't this be a lot easier for us if we just had the category for trespassers and then one other category instead of trying to parse through three? Like we currently have? I mean, we've had a lot of litigation about this. We've had a lot of states changing decisions. I mean, if it's broke, maybe we should fix it, right?
Your Honor, I would respectfully disagree. And I would say if our actual goal is judicial efficiency, then it will never be efficient to have a jury in El Paso, a jury in Dallas, a jury in Austin, a jury in Beaumont look at the same facts and come to different conclusions. And it's also not going to be fair to have every single premises liability case get tried all the way to a jury trial when no duty is owed at the start.
Well, if there's no duty owed, that's already a summary judgment issue. I mean, when you're looking at licensee versus invitee, to me, a licensee, if we're talking about Walmart, nothing is going to change for them because they're giving the same duty to everyone that comes in. The people that are going to be affected, it's homeowners, and it's just, okay, I owe a different duty now to, like, I don't think homeowners already distinguish between an invitee that comes on my property versus a licensee that comes on my property. So why does it matter for them?
Yes, Your Honor. I say I'm out of time. May I briefly answer
Oh,
the
yeah.
question and conclude? Thank you. It matters to the landowner because the trichotomy is built-in fairness. And even if they don't know about the distinction, the law ensures that they owe a duty to the person they invite on their land, and they aren't subjugated to a higher duty that they are not reasonably expected to fulfill. And in conclusion, the trichotomy has been protected and upheld for over a century because it provides that strict balance of fairness for property owners and for plaintiffs. And that's why we agree it should be upheld. Thank you.
Your Honors, Chief Justice, good evening, and may it please the Court. As my co-counsel stated, I am Sam Hagan, and I will be addressing the second issue on appeal today. Your Honors, we argue that the lower courts were correct when they determined that under current Texas law, Ms. Feathermill was a licensee as a matter of law. I will demonstrate this with 2 points. First, Texas has long recognized that the only way someone can qualify as an invitee is under the business invitee doctrine. In fact, they have frequently denied the use of the public invitee doctrine. Secondly, Your Honors, the Texas Supreme Court should not adopt the public invitee doctrine today for 3 main reasons. 1, it's unpredictable. Secondly, inefficient. And 3, will give an undue land burden to landowners across the state. To begin with this analysis, Your Honors, let's look at what case precedents, specifically in Texas, and what this court have said regarding the public invitee doctrine. Just 4 years ago in Porter, the court decided to not use the public invitee doctrine in its analysis. The petitioner was correct. That wasn't the best case to use it, but what that Texas Supreme Court said in the footnote specifically was that the Texas Supreme Court has never officially adopted the public invitee doctrine. Yes, that does mean they did leave the door open for further discussion, but as I will state today, this is not the case that we should officially adopt it, and we never should moving forward.
So the distinction to me between a licensee and an invitee, like the reason it would matter is because you're talking about people that come into your property all the time, frequently, and you are expecting them to come on your property versus an invitee is like kind of a one-off, not so often. But doesn't the public invitee category make sense because you're talking about a piece of land or piece of property that you have opened to the general public, and yeah, they're not there to spend money, but you have invited them to come in all the time, constantly. So why do you not owe a duty to them that you would owe to someone who was there to spend money? What does spending money have to do with the duty?
Yes, Your Honor. Specifically, the reason why spending money is important is because it determines what standard of care you get. So one thing you stated, Your Honor, is that if you're just a licensee, the common misconception what petitioners argue is there is no standard of care, but that is not true. There still is a standard, especially if the landowner does know of some danger, he must properly warn or make sure that danger is gone. So there is a standard of care.
What is it about the spending of money that changes the duty? If it's the same amount of people, if it's still open to the public, why does the fact that they spend or don't spend money change what sort of duty you have to them?
Your Honor, the difference is when that landowner receives some benefit, such as money, which is usually the case, the restatement requires a tangible benefit, that landowner then has funds to actually do repairs on their property and do the necessary steps to ensure it's up to par with the reasonable standard which is required for invitees. When we look at licensees, so that category such as social guests or people you just merely permit onto land, such as just friends coming over, family members, all these other broad categories where people go onto land with an invitation but not for economic purpose, if we impose the same standard as all these big businesses have.
But they wouldn't be public invitees, they would just be regular. Under this doctrine, they wouldn't be public invitees if it's just a social guest that comes over, right?
Your Honor, that's one thing I would like to discuss about the public invitee doctrine. They say it provides stability, and it's very clear and easy to use. But as the judges on this panel have even discussed, determining what an invitation is under that doctrine is quite confusing. Specifically, that doctrine does not just allow an invitation from what people normally consider. They use invitation as a legal word of art, and to determine that, there must be desire or encouragement, which the petitioner must prove. So it requires this higher threshold of what everyone, especially judges, incur, and even jurors, what they understand an invitation to be, for a petitioner to argue what is a desire and encouragement, and they need to prove that. But it doesn't make sense.
Kind of taking the position that we don't have any problem with having these that we don't have any problem with having these already defined categories. So how is the public invitee category more difficult to apply than the categories we already have? We're comfortable with doing that as rules.
Yes, Your Honor. I would argue that it is more confusing. When you look at the business invitee doctrine, it allows a judge to look and see, is there an economic or mutual benefit? That is very easy for courts around the state to administer. All you need to look is a certain fact in the record of, was there $1 paid to the landowner? Is there a potential that they can earn money because of this visit in the future? Very easy to administer. But when you look at invitation and deciding, okay, did this plaintiff actually, or the landowner perhaps, did they have a desire for people to enter their property? That's a very hard standard to prove, and there's not really a good case law to look at. When you look at courts such as Washington, who have adopted the public invitee doctrine, even though they adopted it, they almost never use it, Your Honors. The reason being, it's so hard to administer and when to draw a line. The business invitee
Counsel,
doctrine...
as long as we're drawing lines, why do we necessarily keep this line drawing on the duty side of the equation? Why can't it be on the breach side so that a jury can consider your status as an enterer on land, trespasser, licensee, public invitee, business invitee? It would be more reasonable to treat business invitees with greater protection. It would be unreasonable to ask me to try and protect licensees because they're just there with permission. I'm not getting anything out of that. Why can't I put that under reasonableness instead of under duty?
Yes, Your Honor. So let me make sure I understand your question. You're asking, why is this a duty question? Why is it not a breach question?
Right.
Okay.
I mean, I know why, because that's the way it's been for 102 years. And that's not a good answer today. The answer today is it shouldn't be a duty question any longer. It should be a breach question, or, in your point of view, shouldn't be a breach question, right? So would I ask it right now?
Yes, Your Honor.
Okay.
I completely understand. Thank you.
Okay.
The whole point of the duty element, specifically for landowners, is because landowners and property values are special. So when you look at normal negligence, there's been contributory negligence and duties normally turned on, right? But in this case, when we look at property owners, that is not the case. The petitioner must prove that there's a standard. The reason for that and why we make the judges determine that from the beginning, before we even get to the merits of the case, is clear for two reasons. One, it provides predictability, and two, it's efficient. So let's go to predictability. As my co-counsel was arguing earlier, a jury in some part of Texas can come up with their whole own idea of what reasonable is. Even within the same district, different populations might come to different conclusions of what is reasonable. When we have categories
To which I say, so what?
Yes, Your
That's
Honor.
how life works in the judicial system. You don't get the same money in Dallas for a rear-end car wreck as you do in Houston, or, pick your locations. So expecting things to be roughly equal is pipe dream.
Your Honor, I see your point, but I respectfully disagree when we're determining this aspect. For especially the duty element, the whole purpose of it is kind of a gatekeeping. So we don't flood
Okay,
courts.
and you're right, and it works that way, and the question is not, does it work? The question is, why are we doing it? Why is it better?
Yes, Your Honor. The reason we do is so we can protect landowners, specifically from the insurance aspect. If we open up landowners to all this potential liability, what's going to happen with insurance? It's going to skyrocket at an unprecedented level. When you look at Texas today
Where do you
specifically,
get that?
Yes, Your Honor. This is
there
within.
some study that says that if you allow the trichotomy to go away, then insurance rates increase?
Not specifically with the trichotomy, but when we look at what rises insurance costs, specifically in Texas, right now, the actual legislator is looking at bills and trying to reduce it due to all the natural disasters that are going on. Insurances.
We have 26 states that have basically completely eliminated this distinction, surely we have some data to show whether their insurance costs have risen or not. Do we know one way or the other what the actual outcome effect is? Are those 26 states doing so much worse than us in terms of home ownership? Do we know?
Your Honor, the problem is, especially just in the United States in general, when we look at property insurance, insurance across the board has gone up considerably. All I'm asking is, today we should not imply a rule which will just add fuel to the fire and increase this burden. Across Texas specifically, as I was stating, the legislator has looked and they see this as a problem, especially for new homeowners. Most people can't even afford to get houses. And what I'm trying to state about the tripartite system and the business invitee doctrine is that it works right now. It provides proper liability when it is needed. If we do anything to change that by adding the public invitee doctrine to just open landowners to unlimited potential, we're just adding fuel to the fire to an already serious problem in Texas. And when we look
about this for a minute, that insurance rates are going up because of natural disasters, not because of liability. And so telling me that liability is going to increase them without any kind of data is, frankly, a little bit unconvincing. Whereas if you told me that insurance rates were going up because of hurricanes and hailstorms and, those kind of climate events, I would go, yeah, I believe that. But not liability. Liability hasn't changed. And nobody has any data that says that if you change the standards, here's how much your insurance rates would go up.
Yes, Your Honor, I totally understand that. But I argue, and as my co-counsel argue, and what the legislator is currently focused on shows that they do think this is a concern.
Let me ask you this. Let me go a little bit different direction. If we end up clarifying Texas law today in our decision and announcing that we're going to follow the restatement and we're going to have a public invitee category, do you concede that petitioner meets that definition? And if not, why not?
Your Honor, I argue same answer as the appellate court. The evidence in the record conclusively shows that there was no invitation. Reason for that, when we look at the restatement, as I was discussing earlier, Your Honors, it requires enough evidence for there to be a desire or an encouragement, and specifically states mere permission onto land is not enough. So when we look at the facts on the record, specifically on page 3.
Well, what if we disagree with that? What if we think the notion of invitation is somewhat broader than the Intermediate Court of Appeals?
Yes, Your Honor. We are allowed to come to that conclusion since this is a de novo standard of review. But what I would argue is if the court today does decide that there is enough evidence for a jury to conclusively establish that those elements are met, I would argue that's going to have horrible precedent moving forward. When we look at the public invitee doctrine, it's supposed to be extremely narrow. The reason for that is if we just allow anyone to have some type of invitation, as I was stating earlier, it's going to impose all landowners potentially be liable when anyone comes onto their land, because it's hard to distinguish what exactly is an invitation.
No,
And
that's not true. The definition of the restatement of a public invitee is that you hold the land open to the public, all right? Not that anyone that comes on my land is a public invitee and is owed those duties.
Your Honor, I respectfully disagree when the restatement
I'm
is not
quoting
just...
from the restatement.
Yes, Your Honor. That is a part, land being held open to the public, but when we look into the restatement, it specifically has a requirement for what that invitation is. So yes, part of it, step 1, is land held open to the public, but the second one requires a desire or encouragement to serve as an invitation. So it doesn't qualify that you just invite someone over to your house for dinner. That would be considered a social guest, and the public invitee doctrine would say they are a licensee as a matter of law.
Well, of course, because you're not telling the whole city of Waco to come over for dinner, but your client was inviting the whole city here to come over to his land.
Your Honor, I respectfully disagree with that assessment. When we look at the facts of the record, Mr. Fusemayer never did anything directly to invite people. He
Counsel,
merely
welcome
permitted.
sign.
Counsel, in addition to the welcome sign, he let the Historical Society do a story on him. He let the news do a story on him. Is that not objective evidence of an intent to invite people on his land?
Your Honor, I respectfully disagree. When we look at the restatement, it requires a desire. And when we look at the facts of the record, what is the welcome sign? That is very comparable to just a welcome mat on someone's property. And I understand, let's take a step back. When we see all these
if you
facts,
did have a welcome mat on your front door and then hundreds of people came by your front door every day and knocked and said, hey, what's up? I'd like to take pictures of inside your house. Do you not think that that starts to become a public invitation when people take you up on your welcome offer all the time?
Your Honor, in my
Wouldn't you
opinion,
have a duty to say something different besides welcome at some point?
Your Honor, our side and our defense, when we look at the record, we say it conclusively shows otherwise. An issue, however, is the exact things we're discussing today. The public invitee doctrine is very vague. There's a lot of facts that anyone can decide. Is this an invitation? Is this a desire? Is this an encouragement? And it's very hard to just throw that to a jury and expect them to come up to solid and consistent results across the board.
I mean, isn't that we ask juries to do all the time in all sorts of areas of the laws? We basically say, hey, here's a bunch of facts. What do you think is the appropriate resolution? I mean, that's the purpose. So why are we taking this away from them? It seems like this would be more appropriate for juries to determine what the invitee, whether or not you're a public invitee or not.
Yes, Your Honor. In some instances of tort law specifically, we do allow that. But as Texas has stated, and courts across the country have stated, land ownership is unique and it needs strict structure to correctly impose liability. If we just allow a reasonable standard or a public invitee category that's very vague, it's going to be very hard for landowners to actually protect themselves, such as Mr. Fiesemeyer. And I see I'm out of time.
Sorry, just one quick question. Isn't the protection just to not invite them? Like just to not make it open to the public? That seems like a very easy solution for anyone who has a concern about it. Because they're not getting an economic benefit, so there's no other reason to invite them.
Your Honor, under the current system, you're still allowed to invite people and they have a standard of care. All we're asking is that they don't get the highest standard of care, which is given to business invitees, because they don't have money to actually make the changes that are necessary to meet that standard effectively every time. To conclude, Your Honors, we argue today that this court should continue to follow the clear, stable, and efficient doctrine under the trichotomy approach. All courts across this state have all said we have not adopted the public invitee doctrine. The petitioners have not said anything new or something that hasn't been argued before. And this court has consistently held that the public invitee doctrine is just not right for Texas. I argue we continue that today by keeping bright line rules. Thank you.
May it please the court. Opposing counsel wants the court to elevate labels over facts, but Texas premises liability is always centered on the reality of what happened, not on outdated categories that no longer reflect modern life. The petitioner has 2 points in response.
Haven't you asked the court to adopt a new label, public invitee?
Yes, Your Honor. In adopting a new label as well, it massively expands the category and allows more people to fall under it and more people like Ms. Feathermill to be protected.
So you like some labels?
If the court is not going to abolish the licensee invitee distinction, in the alternative, the petitioner argues that they should adopt a public invitee so our client, Ms. Feathermill, has legal recourse for her injuries that she suffered on Mr. Fiesemeyer's land. Now, the respondents invoke legislative deference, but it's always been within this court's historic role to modify, adapt, and to make fair the rules that have governed common law. Tort law exists to protect the injured and vulnerable and not to give windfall to defendants like Mr. Fiesemeyer and landowners across Texas taking advantage of Texas premises liability in its current state. In response to respondents on issue 2, a reasonable care standard does not overload juries nor landowners and is not overly burdensome. It balances the scales in a pro-defendant area of the law, and instead of being pro-plaintiff, creates an equality across the law that is important and necessary for plaintiffs and the injured like Ms. Feathermill. This case is more than about the trichotomy. It's about whether Texans can rely on the law to protect them when they are injured from dangerous conditions easily discoverable on the land, when the law doesn't impose or force the landowner to do more. If the court is hesitant to establish a blanket duty of reasonable care, it should instead reverse and adopt Section 332 and find that Ms. Feathermill is a public invitee. Thank you.
Thank you. All right, your case is submitted. With that, we will adjourn to deliberate.
Well, thanks all for coming. I think it's great that you come out and support some of your fellow competitors, not just to hear whether or not you're a top speaker. And so appreciate that. I think this competition is the point in the third quarter where things kind of all start to come together. And so I am very grateful to Mike Berry and Jessica Kincaid for putting on, kind of leading the charge, and all of the students who contributed to it. So I want to give them a big round of applause. I want to thank Durham, Pittard, and Spalding. We can't do a competition like this without that sort of support. So shall we please go back to the firm and tell them how grateful we are. This has been fantastic, and thank you. Thanks to you. What's that?
Kirk is well aware.
Okay, good. Well, tell them again, because we want to know. And I'll tell them myself as well, as I have before. So thank you very, very much. Katie, Savannah, JD, and Sam, I do not know who won, but I do know what's at stake. I made it to the final round of the in-school moot court competition, and I lost, and it ruined my career. So just know there's a lot at stake. But yeah, so the winner has to come back and judge next time, and the loser has to come back in like 25 years and be the dean of law school. So, and which one is worse kind of depends on the day, frankly. So
If you only make it to quarterfinals, you get to be Chief Justice, though.
Yeah. I blame it on my partner. As two of you will. In just a moment. So without further ado, we will announce the winner.
All right. This was by one vote, so it was very close, and I'm just going to give a little appellate spiel before we start. I know not all of y'all will go on to be appellate attorneys. I do love it, but what the skills you've learned here apply across the board. If you end up doing transactional, if you end up doing anything, the ability to speak confidently and competently about your issues to anyone is always going to serve you well, even if you become dean of the law school or something different. So I just want to commend all four of y'all on a job that was well done. With that being said, our winner today is the respondents. So congrats, guys.
Okay, we'll turn it over to the moot court officers for awards now.
Ladies and gentlemen, we've heard a lot of thank yous today, but specifically Evan and I want to thank Professor Berry and Professor Kincaid again. Truly, this competition would not be possible without them. So could you please join me in giving them another round of applause? With that, we're going to get into the awards. We're going to begin with the teams who were semifinalists. When we call your name, please come down here and get an award. When you receive an award, after we're all wrapped up, we're going to go out into the hallway and you're all going to take photos together. So once you receive your award, please sit down, but then join us outside. First up, we have Team 18, Justin Paley and Thomas Martin. Next up, we have Team 13, William Tucker and Grace Schultz. Next, we have our finalists, both our runner-up and our champions. So first up, we have our runner-up team, Team 16, Savannah Walker and Catherine Steppick. And finally, we have our winning team, Jake Hatcher and Sam Hagan. Now we're going to get into our oral advocacy awards. So for these first few names that I'm going to call, please stand. We don't have a plaque to give you, but we want to have you stand. Sorry, not my rules. We want to have you stand, and we want to recognize you. After I finish calling the names, we'll give them all a round of applause. So first up, and this is in no particular order. This is not how many speaker points you got. Just have to put that out there. First up, we have Leo Lee. Allie Mills. Evan Patel. Isabella Russell. Michael Rousseau. William Tucker. And finally, Savannah Walker. You may be seated. Next, we're going to get up into our top 3 speakers. We're going to begin with third place, Isha Loray. Come down here.
Am I supposed to come up?
Yes, sorry. We actually have plaques for you guys. Second place, we have Jake Hatcher. And our top speaker for this award, for this competition, we actually want to mention that she volunteered to pair up for this. She didn't have to, and we are especially thankful that she did that. Our top speaker for this competition is Daniela Castillo. Once again, we thank you so much for joining us here today. This is a wonderful competition that we have. I remember it fondly. I didn't make it nearly this far, but I remember it fondly. With that, you're all dismissed. If you've won an award, please come out into the hallway for pictures. Thank you.